The trial court's judgment should be reversed or substantially reduced for 3 reasons. First, the award of attorney's fees must be reversed because the party's contract does not authorize fee shifting in this case. Second, the award of lost profits must be reversed because the plaintiff violated the public policy of Tennessee by using unlicensed independent contractors not employed by him to perform the plumbing work in this case in violation of state licensing laws. Third, the unjust enrichment award for the excavation work must be substantially reduced because all 3 experts in this case, including the plaintiff's own expert, agree that a 100% profit margin for excavation work is exorbitant. I'll address each of these arguments in turn, and I welcome the court's questions. So starting with the attorney's fees. The trial court awarded the fees under a provision of the party's contract as an exception to the American rule. That provision, Section 7, says that if any invoice is not paid when due, 2 things will happen. Interest will occur at 5% per year, and the Tunney Group shall bear all costs of collection, including attorney's fees. Under that plain text, attorney's fees...
Aren't those part of 2 different sentences, and the invoice language doesn't appear in the second sentence, does it?
It is a 2 sentences in Section 7, that's correct. The second sentence has the cost of collection language. And so that begs the question.
The invoice language is not in the second sentence, is it, directly? And you're reading it into the second sentence, but you're not representing to the court that the word invoice appears in the second sentence.
No, certainly not. It's in the first sentence. We're saying that the word cost of collection is in the second sentence. And the question is the cost of collecting what? And to answer that question, you have to read the 2 sentences together. You can't read one sentence in isolation. And I don't know what you would be collecting other than an invoice, which is referenced in the immediately preceding sentence. There's nothing else in the contract that tells you what you would be incurring cost to collect other than an unpaid invoice, which is mentioned in the immediately preceding sentence. So yes, there are 2 sentences, but we think the sentences have to be read together. And there's no dispute that Mr. Pirtle has no unpaid invoices for his plumbing work. He concedes that point on page 23 of his brief. And this lawsuit, what it was about, was not seeking to collect an unpaid invoice. It was seeking to recover lost profits under the contract for work he did not perform under the contract because he was terminated. I think the trial court and Mr. Pirtle have tried to transform this fee shifting provision into a general prevailing party fee shifting provision, which is common. Lots of contracts say if there's litigation around this contract and you prevail, you get your attorney's fees. That's just not what the text of this particular fee shifting provision says. It's limited to the cost of collecting an unpaid invoice. And Tennessee law is clear that courts must enforce fee shifting provisions according to their text and limit it to the circumstances that are expressly authorized by the text of the particular fee shifting provision at issue. We've cited the Boiler Supply and Raley decisions, both from this court, which both involved situations where a party sought to recover fees that were outside of the specific circumstances fee shifting was provided for in the text. And the language in those cases is clear. Legal expenses cannot be recovered if the subject matter of the lawsuit is beyond the terms of the provision. That's Boiler Supply. Raley says a litigant has a contractual right to attorney's fees under the particular circumstances specified in the contract. And so the question here is just, is this particular case specified in the text of the fee shifting provision? We don't think it is. I'll turn now to the trial court's award of lost profits on the plumbing contract. That part of the court's judgment must be reversed because it violates the public policy of Tennessee as expressed in longstanding common law rules that have now been codified by the General Assembly as well.
Counsel, do you have any authority that applies this limitation that you're referencing in the context of a licensed individual who makes use of a subcontractor? And it seems like the authority you're pointing to involves an unlicensed person seeking to obtain their lost profits where they're unable to do so. But do you have any authority from this jurisdiction that applies that in a factual circumstance like the present case where it is a licensed individual who's looking to obtain their lost profits?
This is the first case we know of that seeks to apply the rule to, and I want to be clear, to a specialty where you have a specific statute that says you have to either be a licensed person or be employed by a licensed person to perform plumbing work. You're correct. The other cases are about unlicensed contractors, but we have, the rationale of those cases applies exactly the same, if not more strongly here. And the text of the statute that the General Assembly enacted doesn't limit the rule to a particular licensing violations of failing to hold a license.
The portion of the contract that wasn't performed here, where we end up with this not proceeding forward between the two parties, the individual here, our master plumber, said that he was going to do all of that work himself. Given that testimony, then why does it matter that the subcontractor, how does that come into play when we're talking about lost profits for the finishing or related to the finishing portion of this contract where the plumber says, I'm going to do it myself? I mean, he is licensed, right?
So I think the answer is it's about incentives. I think Judge McBrayer's opinion in Cifuentes, which we've cited, explains the rationale behind this rule about unlicensed contractors not being able to recover. And both the Gene Taylor decision and the statute, 62.6103B, both of them, they don't ask to carve up the particular portion of the project and ask whether the particular portion of the project that they're seeking to recover for was conformed in compliance with licensing laws as to that portion of the project. It's a bright line rule. If you participate in violating Tennessee's licensing laws, we really care about those. They exist to serve very important public purposes, protecting the public. We want this work done by either someone who's licensed or is employed by and working under the direct supervision and control of someone who's licensed. If you violate that, you don't get your lost profits.
Was this issue raised before the trial court?
Yes.
Where would you point us to in terms of where it was raised before the trial court?
We've cited the record citations in our opening brief. We raised, first of all, two issues. It was tried by consent. First of all, we presented evidence without objection, and it's admitted in Pirtle's own testimony that the workers were unlicensed, and B, they were not his employees. We presented that evidence without objection, and then we argued.
Didn't the trial court express concern that this issue had not been raised? And isn't there a reference in the order here that this issue had not been properly raised? Yes,
the trial court said we'd waived it, but that's incorrect for two reasons.
How can it be tried by consent if that's what the trial court's conclusion was in terms of, get me to tried by consent if a trial court says, sure, I don't think this has actually been raised?
So, well, it was tried by consent. The trial court was incorrect about that. So the trial court issued that decision after the trial. So it had already been tried by consent. And the test for trial by consent in the case law that we cite in our reply brief is to try something by consent, this is what has to happen. Implied consent, which is what happened here. You present evidence on the issue, and it's not objected to, and we present argument on the issue to the trial court. In closing argument, we provided copies of the statutes, and it's not objected to. Never once did Mr. Pirtle say at trial, Your Honor, this is unpled, this issue's been waived, it was required to be pled as an affirmative defense, and it wasn't. Never once was that said. So the issue was tried by consent. Under Rule 15.02, it is a valid judgment, and it must be treated as such unless the party objects to trying the issue by consent. So it can't be waived. And the other thing that I think is even more important is that this argument is based on the public policy of Tennessee, and that is an issue that can't be waived by the parties or ignored by the courts under the party presentation principle.
Yeah, and you're saying Mr. Pirtle in his testimony acknowledged that they were unlicensed?
Yes.
Okay, all right. So there's no factual dispute here about the licensing of the plumbers that were working under him? He
subbed out the job to unlicensed plumbers, correct. Yeah, and we've cited the testimony in our brief. We've provided the trial transcript pages, and it's very clear that they were unlicensed and that they were not his employees. That's the other important part of the test, because if they're employees, it's fine. That's permitted under Section 404B of the Plumber Licensing Act. But what's not, and what's very important is we don't want licensed plumbers pulling a plumbing permit for a job, outsourcing the job to unlicensed, potentially unqualified, independent contractors that he does not have the right to control the details of their work performance.
Isn't he still ultimately responsible for the work?
Is he still ultimately responsible for the work? He may be, but he's not able to effectively control the work that's done. That's the we're relying on the common law distinction between employees and independent contractors, which is set forth in cases like SunTrust Bank.
So is the proof, though, that granular, though, that Mr. Pirtle, I mean, it strikes me that what the proof was showing was Mr. Pirtle did, if not, work over the shoulders of these workers, was responsible for the final work product. And to me, that seems to cover what the statute is intended to do here. So, I mean, am I missing something on what the proof was?
So two points there, the proof and then what the statute requires. Okay. The proof, this is on pages 13 through 15 of our brief, is that, one, he testified that the plumbers that work for me are not licensed. That's page 108 of the trial transcript. And two, he explained that the plumbers that he worked for were subs, were his subcontractors. He said that I do not have workers' compensation insurance because I have no W-2 employees. So these were not his employees. The proof was also that he found these two people who did the rough-in work through a contact named George. The guy who did it, Arnolfo, he'd never met before, never worked with him since. They're not his employees. They were essentially day laborers that he subbed out.
That gets to my second point, though, is I'm not sure that the proof went that extra step, that he had no control or wasn't reviewing the work that they submitted. I mean, it seems like to me that you're still complying with the licensure statute if you are reviewing someone's work, even if they're not licensed. I mean, your argument, I think, takes it a little too far, because then you end up requiring everybody in the step of the chain to have a license. There may be very good situations where you want to have someone assisting that is not licensed, like an apprentice, for instance. So, I mean, that's the step I feel like that's missing here.
So I want to be clear, I don't think there's any dispute that these were independent contractors in the traditional common law sense of that term.
Okay.
Which is that they had the right to do the work.
And you could say, the hell with you, Mr. Pirtle, I don't care how you're saying I should do this, I'm just doing it the way I want to do it.
Well, I mean, like any independent contractor, the person who's contracting can terminate you and do the work themselves, and that would have been fine. But I don't think there's any dispute that these people were not people over whom Mr. Pirtle had the legal right as their employer to control the details of their work performance. That's the test. And this court, just to be clear, in SunTrust Bank and other cases cited in SunTrust Bank, has looked at other statutes that use the word employee or employer and said that's a well-defined term. That means that is distinguishing between the common law definition of an employee and the common law definition of an independent contractor, one of whom you have the right to control the details of work performance, one of whom you do not. And that's the licensing statute, for very good reasons, uses the employee term.
Mr. Carver, you're out of time, but I want to ask you a question with respect to the excavation work.
Yes.
So that was a rush job, it sounds like, no firm agreement on price here, and ultimately the court made a decision based on expert testimony. Did it not? I mean, it seems like to me, presented with your position on what the value of these services should be and what Mr. Pearl presented, the court just accepted an evaluation. And I mean, I'm not sure, I'm struggling with what the concern is over that. I mean, courts do that. They pick one piece of evidence over another.
I want to be clear that the court here rejected the unanimous testimony of all three of the experts, including plaintiff's own expert, that a 100% profit margin is unreasonable for an excavation job. So he was awarded double what his costs were. And on the expedited point, any extra costs for the work being expedited were baked in to his costs.
Counsel, one question along that line. He didn't account for his hours, though, didn't? Like his own hours on site in working on this as part of the 32,000 or whatever it was, right? That's not accounted for in terms of that calculation of cost, is it?
It's not clear. If you look at Trial Exhibit 5, there's a payment of $6,000 to Third Coast Excavators, which is the DBA that Mr. Pirtle uses for his excavation work, just like Third Coast Builders is his DBA he's using in this case. So we don't know if that was for his time, but more fundamentally, the 100% profit margin, no matter how much time you spend, is unreasonable according to all three of the experts. They said that you would expect for this type of job, 20% is the maximum that you would expect to make. And he could have put his time in his sheet if he wanted to. I'll reserve the remainder of my time for rebuttal.
Thank you, counsel. Counsel, you may be heard.
May it please the court, my name is Timothy Nichols, and I represent the appellee, John Pirtle, doing business as Third Coast Builders. Let me first address the issue of the attorney's fee award. The trial court awarded approximately $35,000 in attorney's fees, and it looked to the contract between the parties in determining whether there was a provision in the subcontract that allowed for the award of those attorney's fees. The language in the contract is a single sentence. It's not a conflation of two different sentences as the appellee is attempting to make. The single sentence reads, "The Tunney Group shall pay all costs of collection, including, without limitation, reasonable attorney's fees." In our view, that's a very clear establishment that my client had the right to recoup his attorney's fees for costs of collection.
Counsel, don't we have to read it, though, in the context of the prior sentence? It's part of the same paragraph, if I recall correctly here. If any invoice is not paid when due, interest will be added to and payable on all overdue amounts at 5% per year, or the maximum percentage allowed under the applicable laws, whichever is less. Then, turning to the provision you just referenced, the Tunney Group shall pay all cost of collection, including, without limitations, reasonable attorney's fees. In reading those together, doesn't the invoice language essentially bleed into our understanding of what it's referring to as in terms of costs of collection?
I don't think so. I think that in the second sentence that relates to attorney's fees, there's no reference to invoicing, and the prior sentence addresses a separate issue. It addresses interest that would accrue on unpaid invoices. We think the sentence that we rely on addresses a separate issue, and that's the award of attorney's fees.
With regard to presumption, opposing counsel, and you make the argument in your briefing that we should read against the drafter, and therefore if this is essentially unclear, then your client should prevail as a non-drafting party here. Opposing counsel says, yeah, but this is an attorney's fee provision, and so that a presumption is not applicable. I wonder if you could address that argument
Sure.
for us.
I think the primary case that they cited was a case called Cracker Barrel. And in that case, the Court of Appeals addressed whether just the phrase costs were sufficient to trigger the award of attorney's fees. And in that case, they said, well, that's not clear that they were talking about an award of attorney's fees. And they required more precise language to award attorney's fees. In this case, we've got very precise language. Explicitly, attorney's fees are addressed. The second issue in that Cracker Barrel case is that case didn't get into who drafted the contract. So I think the case is distinguishable in that sense. I don't think it's an ambiguous clause in the contract we're dealing with, but I do think to the extent that there is ambiguity, that ambiguity should be construed against the drafter of the contract, the Tunney Group. Let me next address the issue of the unlicensed contracting and Mr. Pirtle's admitted use of subcontractors or independent contractors that were not licensed. The fact of the matter is Mr. Pirtle was himself licensed. Mr. Pirtle himself oversaw the work. Mr. Pirtle obtained the permit. Mr. Pirtle...
Does the record establish supervision over the subcontracted employees in terms of the work that they performed?
Absolutely. There were even occasions during the project where the general contractor expressed dissatisfaction to Mr. Pirtle about some of the work that was occurring, and Mr. Pirtle addressed it and fixed the work and oversaw these subcontractors to make sure the work was done correctly. His work was also, had to go through an inspection process. Codes was involved in inspections, and ultimately, Mr. Pirtle was the one that was responsible for making sure that the work complied with codes, and frankly, there was not an issue of whether or not the work was done correctly and complied with codes. I think the application of the statute 62-6103, which talks about the license requirement for, or the recovery of expenses for unlicensed contractors, this would be a novel application of that statute if a licensed contractor could not recover what they're entitled to. Even if you look to the title of the statute, 62-6103 is titled License Requirement, Recovery of Expenses by Unlicensed Contractor. That's not the situation here. We've got a licensed contractor that is attempting to recover. The other thing I think is significant is the legal doctrine of notice and opportunity to cure. When this licensing issue first arose, a notice of default was sent to Mr. Pirtle. That notice of default raised an issue of potential licensing violation. Mr. Pirtle responded to the notice. He said, I'm not aware that there's any licensing violation or licensing issue. Please give me more information about what I've done wrong. The Tunney Group didn't respond to that. They didn't provide him with any additional information, and instead they said, let's get back to work and let's finish the project. And so we think that there was a notice issue related to this alleged licensing violation. And then the other key point is that when he did return to work, he returned to work, and all work from that point forward was performed by him personally, the licensed plumber. And so, and then when the court awarded lost profits, it noted that he was going to finish the project himself without using any employees.
So the unlicensed workers only did rough-in work?
Correct.
Okay.
Correct. And it was his intent, Mr. Pirtle's intent, to finish the project himself without using those other laborers. Let me finally address the quantum meruit portion of the dispute. And the way that arose is Mr. Pirtle started doing the rough-in plumbing. He finished that work, and there would have been a gap time between when he would come back and finish the finished plumbing portion. During that gap, he was approached by the Tunney Group, who asked him if he could perform some excavation and some grading work on the project. He agreed to do it. Unfortunately, there was no discussion of price. And so the trial court, when it addressed that issue, determined that it was a quantum meruit type claim, and under that analysis, determined that Mr. Pirtle was entitled to the reasonable value of his services. And the court heard lots of proof as to the reasonable value of those services. Heard from Mr. Pirtle and heard from 3 additional experts about what was customary in the industry for charging for excavation and grading work. And what the court found is that customary in the industry is for a per truckload of dirt removed from the site to be used to charge for that work. There could be variance in that approach, depending on whether there was finish grading, rough grading, depending on whether the work was expedited or not expedited.
Counsel, I want to ask a question on the expedited. Am I understanding the trial court's findings correctly, that the trial court essentially, some of the witnesses the trial court did not believe were competent to testify with regard to the expedited cost, and that in the witness's knowledge was more limited in that basis, and the plaintiff's expert was the one who was qualified to address expedited cost? Is that a fair understanding? Am I overstating, understating?
That's somewhat of a fair understanding. The appellee actually presented two different expert witnesses. One of those experts just indicated he doesn't charge anything for expedited work. He doesn't work on that basis. And so he wasn't able to offer any proof about that. The other expert did say that it's appropriate to charge an enhanced fee for expedited work, but my recollection is he didn't have a specific dollar amount that he could tie to that. Mr. Pirtle's expert, I think, went into far greater detail about the expedited work and how that might be factored into the pricing.
Did Mr. Pirtle account for his hours as part of the $32,000, or is that unaccounted for?
That's unaccounted for. He was actually out on the project site operating what's called a laser level to shoot elevations for the grading work. He was monitoring, he was out on the project site monitoring work performed by others, and that work is not accounted for in his in the expenses.
You're saying it's not accounted for?
It is not accounted for. And that was an important factor for the trial court in determining that this sort of cost plus approach was not an appropriate mechanism to use in this particular case, because he was performing work himself. The trial court also noted that different contractors might use different kinds of equipment to do the work, and there would be different expenses, and contractors might even use their own equipment that they owned, and there wouldn't be expenses for that kind of situation. And so the trial court did consider the approach they're advocating for, but found that the other approach, the per truckload mechanism to establish pricing, was better for this case and in conformity with industry standards. Unless there are other questions, that's what would conclude my part. We're asking for the trial court's decision essentially to be upheld in every way, and for the case also to be remanded to the trial court for consideration for additional attorney's fees on appeal.
Thank you, counsel. Counsel, you may be heard in rebuttal.
Three brief points. Tennessee's General Assembly has expressed a public policy that for plumbing work, the work needs to be performed by someone with a plumber's license or employed by a person with a plumber's license, so that they have the right to control the details of their work performance as the employee. I believe that opposing counsel conceded that Pirtle admitted that he used unlicensed subcontractors who were not his employees. So that's a violation of Tennessee's public policy, and I agree that in this case it's slightly different than the unlicensed contractors situations from prior cases, but the reasoning is exactly the same. We want to incentivize compliance with Tennessee's licensing requirements. We don't want unqualified, unlicensed people working on these jobs where public safety is at stake. And here, the person who needs to have the incentive to comply is the master licensed plumber. He's the person who is able to determine who works on that job site, whether they are licensed or employed by him and under his direct supervision and control. So we think that the reasoning of Gene Taylor and the cases Cifuentes applying the statute applies squarely here. If Pirtle's position is adopted, there is nothing to stop a licensed plumber from pulling the plumbing permit, outsourcing the work to unlicensed, unqualified, independent contractors, and letting them do the work, and doing it more cheaply than he could otherwise do. And then if there's a payment dispute with his subs, not paying them and saying, well, you violated the statute, so you can't recover anything other than your documented expenses. Adopting his position would effectively create a massive loophole in Tennessee's licensing requirements. On the excavation work, to the question about his time, so if you look at what we're advocating for, which is a 20% markup, that's $38,400. The 100% markup he got is $65,000. I don't think there's any way that his time can be worth $26,600 for a few days, for several days of work on the two excavating portions of the project. The time can't make up that difference.
Counsel, running short on time, can I ask you to address the presumption issue again with regard to attorney's fees? Opposing counsel essentially says the presumption should still be read against Tunney because the language of attorney's fees in particular does appear here, which it does. The language appears here. I'm assuming you disagree with that. You're suggesting that the presumption should instead be, in terms of clarity. Can you walk me through that a little bit? 2
points. We don't think the presumption comes up because the language is not ambiguous.
Assuming it's ambiguous.
Second, if it is ambiguous, I think Cracker Barrel expresses a view that basically fee provisions are to be strictly construed. And yes, Cracker Barrel itself was about whether or not the contract authorizes fee shifting at all. But the reason that it gave for that is that it wants certainty in contracting about whether or not you're going to be liable for fees. That reasoning applies equally to the scope of the fee shifting award, which is that you need to be clear. If you're going to force somebody to violate the American rule and pay their fees, it needs to be clear that you're doing it and what the scope of that exception to the American rule is.
So do we read that provision then sort of like a demand clause? In other words, if payment is conditioned on demand, that's the way this attorney fees. So you had to have issued an invoice before that to ever be triggered. Is that what you're saying?
So for example, if for the rough-in work he was paid for, if my client if he had issued the rough-in invoice, my client hadn't paid it, and he'd sued to collect it, we would be on the hook for fees. What happened instead is we paid the rough-in invoice, and then we terminated him before he ever did the trim-out work. And now he's come back and said, I didn't do the trim-out work, I don't have an invoice for the trim-out work, but I want to be paid for the trim-out work because I was wrongfully terminated. That's just not a situation that's covered by the text of this narrow, a little bit unusual fee-shifting provision.
Thank you, counsel. Your time
Thank you.
has expired. We thank counsel for being here this morning. That will conclude this morning's hearing. Madam Clerk, will you please call the next case?
Clint Johnson versus Airtight Resources, Inc. et al.
Good morning.
Good morning, counsel. You may be heard.